Thank you very much. Jennifer has been the principal legal assistant in the defence team of Laurent Gbagbo since 2011. She has also worked for many years for Emmanuel Artit and Associates law firm in Paris. Jennifer specialises in international criminal law, but also has experience covering a great number of other aspects of criminal law in her domestic practice. In addition, she has worked at the French Parliament and for NGOs, including GISTI, an organisation that provides legal support for immigrants in France, and the French Red Cross. Jennifer teaches international humanitarian law and international criminal law, and has been a trainer of defence lawyers in the past. Thank you very much.
I also think it's important to keep in mind some key points that are specific to investigation in international criminal cases. Each one of us should keep in mind the structural imbalance in means and the perception available to defense and to prosecution. The structural context of violence, and it doesn't matter if you're defense or OTP. In both cases, you will investigate after events that occurred in a country that will have left scars on the population. You must have that in mind at all times. For example, in the Gbagbo case, the new authorities can put your potential witnesses in danger, and potential witnesses can be scared. Also, the presence of the United Nations isn't always welcome. So, if you decide to travel in United Nations cars, this might be a problem and prevent you from meeting or even finding a good witness. Each case is different, but the context of violence is important because it explains that there are rules specific to international cases that aim at protecting you, your witnesses that are potential victims. So as a defense lawyer, you know the reality on the field. So when you address issues concerning your investigation before the judges, keep in mind to be simple and pragmatic. Explain to them the realities of investigating on the ground in your case. Also, don't forget that the burden of proof lies on the prosecution, not on the defense. The role of the defense, in addition of building your own case, is also to challenge the evidence presented by the prosecution. This will have an impact on how you organize your investigation. I will talk, of course, a lot about the Gbagbo case, and in the Gbagbo case, this means about 138 witnesses, 10 expert witnesses, approximately 10,000 documents, incriminating, or what we call Rule 77. The evidence has tripled since the confirmation hearing. You have to take that into account when you investigate. Which means that at trial stage, you are preparing your upcoming investigations on a rolling basis, taking into account the witness's prior testimony and the witness's testimony in court after examination in chief by the prosecution and after cross-examination by the defense. Of course, now focusing on the prosecution's case. Also be aware that there is no harmonization between investigation protocols at the ICC yet, and that you will have to negotiate those protocols at different stages of the proceedings. This is a very important point, and I'll come back to that a little bit later on. Finally, keep in mind that during investigations and a trial, time is of the essence. So today, I would like to talk more specifically about the conduct of an investigation. So I will present what I call a simplified guide to investigation. Then I will address the investigation protocols at the ICC And if we have some time left, maybe some more practical points that are useful to know when you go investigate, and also depending on the system in place at the ICC. So, a guide to investigations. When you go investigate, you are building a case. The idea is to build the strongest case possible to defend your client. At the ICC, the core of your case is in the testimony of witnesses. I might be stating the obvious here, but a lot of lawyers come from a practice from civil law, for example, where the testimonies are not the core of your case. And also, we have to stress that in international criminal law, the number of witnesses are much more important. You will have to cross-reference or corroborate witness statements. So, testimony of witnesses is going to be the main focus in your investigative work. And the robustness of your case will depend on the plausibility of a testimony of your witness or his or her credibility. In order to know if it is useful to bring a witness, you must first ascertain their usefulness and plausibility of their testimony. You have to judge yourself the plausibility of the narrative of the witness and his degree of credibility. So to do this, you must ask the right questions. Confront systematically your exchange with a witness to your common sense, your logic, but also your knowledge of the events and what other witnesses will have said. You must, through your questions, allow the witness to reconstruct what he or she has experienced, and thus give the judge a sense of reality, not only of the events he or she witnessed or the suffering she endured, but ask questions that allow to understand who is responsible of the violence or participated to creating a violent context. You will have to find a witness that contradicts the evidence of the prosecution's witnesses and confirms evidence given by some of the prosecution witnesses during cross-examination. That is why, when you investigate, you should examine the witness and cross-examine your potential witness before deciding if you're going to call the witness to the stand or not. This is how you ensure quality of your own witnesses, and as such your own case. And especially at the ICC, where you might not have witness proofing. In the Gbagbo case, again, there is no witness preparation, which means that it is possible that you have to call a witness that you haven't spoken to in years. As an introduction, I talked about the difference between the means of the prosecution and the defense. The means to investigate for defense are limited. You cannot go on the field whenever you want. So if you have a good witness, make sure you get a good statement. Because if you don't have witness proofing, for example, you might have to call a witness 2, 3, 4, 5 years after you actually talk to him. If you did your job well during the investigation, this will not be a problem. And you'll be on the safe side. This is very important, even if the defense doesn't need to prove its case beyond a reasonable doubt. That's the prosecution's job. You still have to present a strong case that will at the same time show the flaws of the prosecution's case and present a stronger and more credible narrative. So when you're on the field, what kind of witnesses are you looking for? You should start with crime-based witnesses. You need to obtain detailed and direct testimony of witnesses that are potential victims. When you question them on the field, they must explain who they are, why they were on the spot. What were they doing there? What did they see? Then, those crime-based witnesses have to explain what happened to them and what they personally experienced or saw other people undergo. It is important that they give details of the violence they witnessed or endured. Even without being directly victimized, a person can give useful information by restoring what he or she has witnessed or seen. It is also crucial that the witness gives all the elements he or she remembers concerning the perpetrators of the crimes. Name, rank, unity, uniform, appearance, etc. In international cases, and we heard the presentation of Judge Henderson, context is very important. It might be war crimes, it might be crime against humanity, but there might, in both cases, whether it is war crimes or crimes against humanity, be a war context. So identifying criminals potential perpetrators is important. Sexual crimes. They must be explicitly denounced, even if it's not always easy to obtain evidence from witnesses. On this matter, it might be useful to have a female on the team of investigations, because it requires great skills and training to find, in the first place, meet, reassure, and question the victims of sexual violence that are, in most cases, women. This is the reality. And during investigations, it is important to reassure the witness that everything he says to an investigator will remain confidential. That means exists to preserve his anonymity and security in court proceedings. I will get back to this. Second category of witnesses are the hearsay witnesses. Of course, the value of their testimony is not that strong, but again, as defense lawyers, you don't have to prove your case beyond a reasonable doubt. You have to create doubt concerning the prosecution's case. And hearsay witnesses can be useful as they corroborate other evidence that you have gathered or has unfolded during examination or cross-examination of witnesses during the prosecution's case. Context witnesses. Here it's about getting statement of people who, because of their responsibilities or capacities, know what really happened during a repression or a war. The statement of those witnesses will supplement those of direct witnesses and give an understanding of the sequence of events. It is therefore a matter of questioning politicians, academics, journalists, lawyers, members of NGOs, civil society leaders, including church leaders, and so on. These statements do not replace those of witnesses, but constitute an indispensable addition to your case. And finally, expert witnesses. What type of experts may be required really depends on the case and the evidence presented by the prosecution. Given the subjects you are confronted with, you will most probably have to find an expert in ballistics, forensic science, a forensic pathologist, and so on. They will need, for example, to analyze reports presented by the prosecution. But you should not wait for the prosecution to present his case, because you might have documents that you want to get analyzed by experts. And what is an expert? In the Bagbo case, we had a very interesting debate concerning an NGO member of Human Rights Watch. The prosecution called this witness, and this is public, and it appeared from his testimony that he was going to give a testimony as an expert witness, but it was not said clearly. The parties started a debate to know if he was an expert or not. The chamber decided he was not an expert, so this limited the scope of his testimony to what he has personally seen or experienced. So it is also important to analyze what type of witness is being called or what your witness is going to be, to avoid that the testimony of a potential witness will be limited in court. So once you find those witnesses, what do? You can take, or you should take, their testimony. You need to know that as a defense lawyer, you are not required to take notes of all interviews you conduct with potential witnesses. You can also choose to not take written statements. Sometimes, for strategic reasons, this choice can be made. Keep in mind that the disclosure requirements are not the same for the defense, as they don't have to prove their case beyond a reasonable doubt, and they don't have the burden of proof. But if you do decide to call a witness you interviewed, we would recommend you take his prior statement instead of just a will say. The number of statements can be important, and if you don't have witness preparation in your case, you will even more so need a good written prior statement. So, in practice, I'm not going to show you a witness form because, like in court, the documents are confidential, but then we talk about it in public hearings for long hours. So the document is confidential, but still for you to keep in mind things that need to appear on your witness statement when you're having a procedure in front of the ICC. You have to take anything that identifies the person, its name, other names that he's used, of course his date of birth, his nationality. In lots of cases in front of the ICC, ethnic origin is important. The languages he or she speaks fluently or not, the language you used when you actually took this statement, their occupation, etc. It is also important to put down the person who is actually taking down the statement. This will be very important also for your chain of custody. So once you got the person in front of you, he fills in the form. Then you start questioning him. I'm not going to repeat what I already said, but keep in mind that the person must describe precisely what happened when an incident broke out. He has to get into detail of the crimes he was a victim of or that he witnessed. And above all, he must give names of perpetrators if he does know them. You have to ask the right questions, but the witness must remain free of its own narrative. The balance between the two is important, but again, that's why I started this presentation by saying your ethics as a lawyer will guide you through that. On a more technical point, all statements must be completed and initialed on each page, dated and signed. Attached to any statement, you need a double-sided copy of an identity document of the person who testifies. I might be stating the obvious again, but it happens a lot in the procedures that those informations are lacking. The authenticity of the statement and the context in which it was taken can be questioned. You do not want that. If the person who testifies is illiterate, the person who took his statement must indicate it on the last page, sign it himself or herself, and attach its own document of identity. During your investigations, you will also collect documents. Any document that supports the witness account of what happened, photographs, injuries, medical certificates, videos that have been provided by the witness must be mentioned in the statement and referred to as an annex of that statement. This is essential because you will have a clear chain of custody of the document. Any element used by the witness to explain a course of events, for example, a map on which the witness indicates his whereabouts, or when a shooting occurred, for example, must be marked by the witness and mentioned in his statement. We would recommend that when you go investigate, you always carry maps with you that you can show a witness. For documents such as photographs or videos taken into connection with an incident you are investigating, you should always have those documents with you and try to get them authenticated by a witness, by showing it to the witness. Because if you have a video of an incident that seems to have taken place at a certain point in time, and the witness in his narrative seems to say that he could have been present at the location at that moment, it's appropriate to show him the video. The witness may specify the date and place of the incident in the video for the benefit of the investigator and might provide other useful information. In doing so, it validates and authenticates the video. The same video can be shown to other witnesses so that the information given by the first witness can be cross-referenced. Those are the basic things when you're actually on the field investigating. But before you go investigate, you have to negotiate what we call investigation protocols. At the ICC, to obtain your evidence, you must respect a fair amount of protocols. These protocols will either restrict or expand the leeway and discretion you have during your investigations. I won't get into the detail of all those protocols today, but I think it is important that you are aware of the existence, but even more so that you are, as a defense lawyer in a new case, you will have to negotiate these protocols with other parties and even on some topics with the legal representative of victims. This negotiation phase is crucial for you as defense lawyers, especially because the prosecution has already started his investigation and might even be finishing. So the protocols will concern you primarily. Those protocols are going to be guidelines or code of conduct during your investigation. It is a guarantee for you and it will protect yourself, and it might also be a help to avoid Article 70 proceedings. Each case at the ICC has its own investigation protocols. So you will always have to use your own protocols, but each protocol will of course be inspired by the existing protocols, and the inclination today is to an harmonization of these protocols. And as Judge Henderson said in the Bagbo case, and I will quote you, "We strive to move away from a Bemba approach, a Kenyatta approach, a Bagbo approach, to the protocols which would be protocols adopted by the Court of the ICC, which would be general, but which of course will be tailor-made to deal with the specific issues. So what you're really doing is being pioneers, part of history, as we move forward." End of quote. So every lawyer in a new case has to keep in mind the role he has to play in this exercise of harmonization. And I think it is fundamental to try to obtain realistic clauses and arrangement in those protocols, to try to make sure that these protocols don't violate the right of the defense, and finally to ensure equality of arms with the prosecution. And I will take one example. The protocol on disclosure of identity of witnesses of the other parties, the use of confidential information in the course of investigation. That's the title of the protocol. You can see already how complicated it might be. I'm not going to get into the detail of this protocol, but the idea is to understand how to use this protocol in the field and how it impacts your work on the field. Let's talk about the general use of confidential information during an investigation. For example, when you have to show a confidential document to a witness. In the backbone protocol, it is stated that, and I quote, confidential information may only be disclosed to the public where such disclosure is directly and specifically necessary for the preparation and presentation of their case. End of quote. You will find this principle in pretty much each protocol at the ICC. The language is not very clear, and this is a typical example of the fact that your code of conduct will guide you in your decision to disclose or not confidential information to a witness you're meeting in the field. It should be your call. You are the only one who can evaluate the necessity to disclose such information. But the fact is that if you decide to go forward with such a disclosure, you have to protect yourself, your investigation, and the person you're interviewing. So if you decide to disclose confidential information to the public, because that's the term, you have to be educational about it. You have to explain to that person the confidential nature of the information, which means in practice that, in my opinion, you should make the person you are interviewing sign a document attesting you did so. We always travel with such documents with us, we already drafted, printed out, and if we decide to show such document to witness, we'll make him sign that document. We explain to him it's confidential, he cannot talk about it, not even to his brother, his family, because he might see something on a picture, for example, that reminds him of something, and he wants to talk about it with his family. He cannot do that, because it's a confidential information gathered, either by the prosecution or by us. So be aware about putting into practice a protocol. Those are not just rules. It has to guide your every step. The same applies to the record you are supposed to keep concerning such disclosure. The protocol is very clear about what it should specify. So in practice, I strongly advise any team to put in place a procedure to make sure to apply such a protocol, just to be on the safe side. My advice would to be always carry blank tables that allow you to register all the information you need when meeting with a potential source or witness. Those documents can take a lot of space. I took just one example, again, I'm not going to show it to you, but just based on one protocol. I mean, it's a very long and very complex table. Be careful, you need them, but on the other hand, it's confidential. Keep those documents closed, take security measures to be safe as much as possible, and that those documents, of course, don't leak. Those documents are also fundamental for the quality of your evidence and for the chain of custody of your evidence. This means you have to prepare these documents before you leave on mission, you have to create them, print them out before you leave, and you need to carry them with you as a diary of your mission. You need to make it a reflex when you investigate to record every step you undertake, the people you meet, the evidence you use, and so on. It's like a human chain of custody. For example, if you meet a person, but you're not sure you're going to see him again, but you might be interested, we also have documents where we just put names of people, their contact information. Don't lose the contact information of a witness, because if you want to call him again, it can be complicated. Honestly, it can already be complicated because the numbers change. So the more information you have to find your witness, to keep contact with your witness, the safer you are. The human chain of custody is very, very important during investigation. It protects you, your witness, and your work. I'm sure such an overregulation could be quite shocking to some of you, because as lawyers, we are bound by a code of conduct, and it should be assumed that we take all the necessary precautions when disclosing confidential information. Each defense team is following its own strategy and line of investigation, and it should have as much leeway as possible. But we need to be realistic. In a context of violence mentioned earlier, and the unspoken suspicion towards defense lawyers makes it mandatory to be extra careful when collecting evidence. evidence should be collected by your team only. You have no idea what other people may do. You have to take any guarantee you can to protect yourself and your witnesses. And also, you want to make sure that your evidence cannot be challenged on a technicality. On a last note, I wanted to talk a little bit about more practical aspect of investigation. I will not get into the detail of logistics of an investigation, but I would like to address some important practical points that I think are useful to know. First of all, if you organize a meeting with a witness, this witness might ask for you to pay his lunch or organize transport for him. Be careful, this is not what you're supposed to do. And again, trace every step that you're going to undertake. But be pedagogic about it, like we say in French. Explain to the witness why you cannot pay for his lunch, why you cannot organize his transport yet. That once he will be a witness and you decide to call him, then he might have other guarantees and be taken charge of, but not yet. Explain and take no risk. Concerning safety, sometimes, before the witness is accepted as a witness in a procedure, you have to anticipate things to protect him. For example, in the Gabonese case, we represent political opponents and a lot of victims, but there is not even a situation concerning Gabon yet. The prosecution might investigate because there has been a referral, but we don't know yet. So you put in place your own structures to ensure the anonymity and the confidentiality of those victims and witnesses that can be put in danger. For example, you can ask the help of the EU. That's one of the things that we did in this case. As a more general point, the VWU can be of a great help, but you know your case best. They're not always going to be the best advice, and they don't always know what kind of protective measures they can offer. For example, in the beginning of the Gbagbo case, the first thing they told us was, don't worry, we have a very good relationship with local police. They will take care of all your witnesses. Maybe in other cases, like the Kenya cases, or, I don't even want to talk about other cases because you never know exactly what's happening, but you, as a defense lawyer, you do know what's happening in your case. And that would have been putting our potential witnesses directly in the hand of police in Ivory Coast. Probably, at least they were going to be tortured. So you have to be aware of that. Don't put yourself in the system as such. Make sure that your witnesses are safe and that you have enough information to know what's actually going on the field. On a more technical note, anticipate your missions. Defense teams are understaffed. CSS, Council Support Section, can interfere in ways you don't even think of or anticipate in the conduct of your mission. For example, just before the confirmation of charges hearing, we planned a big mission and each team member had a specific role to play. When we submitted our mission plan, as much in advance as possible, CSS considered that some of the team members did not have to go. We had to go in front of the judges to discuss this matter, and the judges reminded CSS that the defense lawyers are independent and know best how they need to conduct their investigation. But of course this took time, and we anticipated that, because even if the judges decided we can do our mission like we wanted, maybe we would have need to ask for a postponement of the confirmation of charges hearing, and maybe they would have said yes, or maybe no. So it's your responsibility to anticipate those things as much as possible. Of course, reality on the field, some things you cannot anticipate, but it's your duty to anticipate as much as possible. Also anticipate if you need cooperation of a state. For example, if some of the witnesses you want to meet are detained, well, you have to make arrangements to make that happen. Anticipate it before you go. Anticipate if you want to meet a witness from the other party. For that, also, there's a protocol in place. You have to put that protocol into motion before you go in the field. As a conclusion, I wanted to say that the guidelines I addressed today are, I think, based on common sense and experience in the field, and I hope that sharing this experience is helpful, because sharing is caring. And on that note, I wanted to say that, in my opinion, the real secret to a good investigation and building a strong case, secret I am happy to share, it is caring. You have to be really interested in people. If you meet a member of an NGO, a witness, a government official, it doesn't matter. You have to be curious about who they are, what they're willing to talk about or not. You have to be humble enough to learn from them, to try to understand the different cultural codes, observe body language, respect customs, try to understand linguistic subtleties, what is meant in the unsaid. If you make that effort, then you can be informed enough as a lawyer to effectively participate in the unfolding of the truth. We all, prosecutors, legal representatives of victims, judges and defense lawyers, have a role to play, and in international criminal law we must be even more curious and specialized, because the responsibility that lays on each one of us is tremendous. Thank you very much.
Thank you very much indeed, Jennifer. That was a very rich and very practical presentation, full of detail and excellent tips for conducting effective investigations on the ground. And that's based on your obvious, extensive real-life experience of conducting investigations. But there was one thing that you said, there were many things that you said that really stuck out for me, but one thing in particular that stuck out for me is what you said towards the beginning of your intervention, where you said that in preparing a witness, a potential defense witness, you have to examine the witness yourself and even cross-examine the witness, test their evidence to make sure that what the witness is telling you is true, I guess. But this raises an important and thorny issue, doesn't it? Because there is a line between testing a potential defense witness on the one hand and running the risk of later being criticized of coaching the witness. When conducting investigations, when you're asking a witness about what he or she saw or did or experienced and whatnot, in the way that you ask the questions, you have to be careful, don't you, to not create a situation where the witness starts telling you what he or she thinks you want to hear. This can cause the lawyer problems further down the line and exposes the lawyer or the investigator to criticisms of coaching.
To respond to that, that's why first of all, I stress that the victim needs to be free of his narrative. That's very important. And I think, now you're raising another question, that is the definition of what is an examination and a cross-examination. Because if you do it right, you're not coaching a victim, you're testing if it's credible what he's saying, and that is a professional and neutral exercise. Well, should be. Coaching is different, and that brings us more to the witness proofing. Is witness proofing something that should be done or not? In our case, it's decided not to, and we can actually see it on a day-to-day basis, because a lot of witnesses of the prosecution, because we're in a prosecution case, come with a total different story. But then when you see that, you're thinking, hey, if I was investigating and it would have been my witness, if I was on the field, maybe if the investigator had asked those few extra questions that relate to a cross-examination, maybe he would have been aware of the quality of the testimony and wouldn't have called that witness. Because also some witnesses who are not well examined by your investigator without coaching end up to be hostile witnesses. And we see that a lot. And I'm not going to get into the techniques of the hostile witnesses, but you don't want that for you. So for you as a defense lawyer, you want to make sure that the witnesses you're going to call are actually strong enough to present a good narrative that is his narrative, but will stand up in court and the standards that are put out in court.
Absolutely. Well, once again, thank you very much. We've caught up a bit of time, but nevertheless we are running over. So what I suggest we do is take a coffee break now.